Welcome to Employment Law This Week. I'm George Whipple. This week, we focus on employee mobility, an area of law that's top of mind for many employers and employees at all levels. The laws that apply to tools like non-compete and non-solicitation agreements are changing almost daily in the courts and legislatures. And companies are finding it challenging to protect their confidential information, balance employee interests, and have enforceable agreements. Aime Dempsey is here with an update on some of the latest legislation in this area.
Just a couple of weeks ago, on April 26th, bills were proposed in both the United States House and the United States Senate that would ban non-compete agreements. Non-compete agreements are actually right now only banned in 3 states, California, Oklahoma, and North Dakota. So this would be a broad nationwide ban for any employers who engage in commerce or who make products engaged in commerce. In New York City, last summer, there's a law proposed to restrict non-competes for low-wage workers.
In terms of enforcement, employers have been watching and waiting to see whether the DOJ's antitrust division will continue the Obama-era emphasis on anti-poaching agreements and other mobility issues in the Trump administration.
It looks like under this administration, the antitrust guidance will remain a priority. In October of 2016, the Department of Justice Antitrust Division announced a priority to enforce rules against no-poach agreements between employers. In January of this year, the DOJ Antitrust Division announced that it would be aggressively going after employers that violate the no-poach guidelines.
As the law in this area continues to evolve, so does litigation. Recent rulings have created some further guidance that can help employers seeking to protect their interests and also to help them to know when to litigate. Here's Pete Steinmeier with more.
The lessons that employers can draw from recent non-compete and trade secret cases are that courts are reluctant to restrain an individual from going to work. However, if there was an actual theft of trade secrets, a court will be far more likely to grant injunctive relief. So the cases that we see actually going to court and being filed tend to be those where there was an actual theft.
California is well known for its strict limitation on employers in this area. State law prohibits nearly all non-competition and non-solicitation agreements. Jonathan Brenner tells us how, even in California, some employee departure protocols can help protect trade secrets.
Having well-prepared and thorough exit procedures for employees can be very helpful. Procedures that include an exit interview process, processes for the return of equipment and other property, and the return of information, including information stored on the cloud or other web-based storage media, and an acknowledgement and certification form that serves as a reminder and statement of intent to comply with confidentiality obligations can all be very helpful, and they're very important features of such exit procedures. There are some more substantive arrangements that are at least possible in appropriate circumstances. Agreements for terms with employees that can't be terminated at will early on both sides is one example of that. Deferred compensation arrangements with vesting conditions as incentive for employees to stay on the job and not leave for a competitor, and even ERISA plans that contain non-competition restrictions, which, at least as a matter of federal ERISA law, can be enforceable.
One option employers in all jurisdictions can consider is the garden leave provision.
Garden leave provisions are clauses under which an employee will give 30 to 90 days advance notice of their resignation. They help employers because they are an alternative to a traditional non-compete. Because they're shorter in length and because the employee is paid during the garden leave period, both employees and their new employers tend not to challenge them, and courts are more likely to enforce them.
Thanks to Pete, Amy, and Jonathan for your insights. You can expect to see more new legislation and litigation as the year progresses. And of course, you can learn all about the new developments right here on Employment Law This Week. That's it for our special edition. Thank you very much for watching, and we'll see you next time.